Video that I'd like to put up today has to do generally just with emergency matters in the family court. These are not required by the Supreme Court order, but they are sometimes things that happen in the ordinary course of business. If you have a custody case, if you have a divorce, if you have some sort of paternity or support case that has provisions regarding parenting time or restrictions or rules of behavior, sometimes things can be an emergency. And so I just wanted to give you some insight as to how to handle that during the time of court closure. The court is only going to handle those matters that are true emergencies. And so it may be that your idea of what an emergency is and the judge's office of the idea of what an emergency is different. And so anything that you feel it needs to be handled, if the judge's office does not feel it's an emergency, you'll need to schedule that for a hearing as soon as the courts reopen. If something is an emergency, though, and you wish to have the matter heard during the time of the court closure, there are a couple of ways that that can be accomplished. One is you can file an emergency motion. What you would need to do is contact the judge's office directly, and I want to make this point very clear. You are going to need to do that through the county website or through the email address of the judge's staff. Most court offices are closed, and so leaving a voicemail is not a reliable way to get your matter before the court. If you have the judge's staff's email from prior correspondence, or you can look it up on the county's website, then you should email the staff directly to file your motion. If you file something as an emergency motion, you need to serve the other side or the attorney for the other side with a copy of that by email and let the judge's staff know that you have done that. If that's the case, the judge's staff will review the motion and determine whether it's an emergency and will take any necessary action. Response would be by email, so that information has to be provided. The other way that a matter can come to the court is through a request for an ex parte order. If you have no experience with that, an ex parte order would be something that's such an emergency that the court would consider granting an order without a hearing. If you believe that your situation is so urgent that you need action that would stop irreparable harm from occurring, then you may file your action as an ex parte request. It's a motion for an ex parte order. You can email that to the judge's staff, and the judge's staff will consider it. It will either be granted or denied. If it's granted, then you need to serve the other side or the other attorney with the order and execute on what the order says. If it's denied, then that you are free to either notice the other side that you need this done as an emergency and the court will make that decision, or you can schedule the hearing as soon as the court reopens. I hope these videos have been helpful, and again, we are here to serve you during this time of court closure. Thank you.